Welcome to Cordell and Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Welcome back, everyone, to Cordell's Men's Divorce Podcast. I am Marcie Patton Coffman, a senior litigation partner here at Cordell. I've been with the firm for a little over 12 years now, and I work out of our Cincinnati office. As we have many offices all over the country, please feel free to schedule a virtual consult with us. You can do it by calling 1-866-DADS-LAW, or you can visit us at cordellandcordell.com. Today, we are here with Kevin Mammola, one of our outstanding lead litigators in Georgia. Kevin, why don't you tell us a little bit about yourself?
Thanks, Marcie. I've been with the firm for a little over 13 years, or right at about 13 years. I'm a member of on the lead litigator team. I'm also a member of our appellate practice team as well. And I work out of the Alpharetta office, but handle a lot of cases, obviously, in the North Metro area, and work closely with the rest of our team in the Atlanta and surrounding offices as well.
Great. Well, thank you so much for taking the time to help us out today and talking to our viewers and listeners about modifying visitation and custody. So when we have a client come in and that is what their goal is, what is it that they need to know? What's the difference between modifying visitation versus changing custody?
Sure, that's a good question. And so in Georgia, so I'm going to address it as it is in Georgia. It may be similar in other states. If someone is looking to modify child custody, it's a fairly different or different standard than if someone just wants to change their visitation schedule. So it depends on what our clients are looking to achieve. If they're looking to modify custody, the standard in Georgia is that they must show that there's been a material change in circumstances that's occurred since the entry of the last order that warrants a modification of custody. And the difference of if you're just looking to modify visitation or the parenting time schedule in Georgia, you basically just need to show that the requested modification is in the child or the children's best interests. That's kind of in a nutshell, that's the difference of the two. Now, with child custody, what we're typically looking for are some big factors that will persuade the court to change the child custody arrangement, which in Georgia, it's a little bit tough to do at times, but there's certainly several indications or several factors that come into play where someone could modify custody. In my experience, the most clear-cut one may be if someone is experiencing like a mental health crisis or having mental health problems, and they're just not in a position to be able to take care of the children. Basically, in that situation, you'd be contending that the other parent is not able to safely monitor and be the primary custodian of the children. That's kind of a clear-cut, easy example. If you're going to try to modify custody without facts like that, then you really need to sit down with your attorney and describe all the factors that have you concerned for that parent acting as the children's primary custodian. And there could be a myriad of factors. And in Georgia, we don't have a statute that per se says to modify child custody, these are the things you must show. It's just material changes in circumstances, which does, I guess, could be subjective or vary from court to court or judge to judge. But basically what you're looking for is major changes that have occurred such that the custodial arrangement that is the current court order is no longer in the children's best interests.
Here in Ohio, when we do a change of custody versus a modification of parenting time and or visitation, ours is twofold. We have to show a change of circumstances and first, we have to show change of circumstances first, and then that's followed up by a best interest standard. Is that similar in Georgia?
Actually, that's spot on. I probably skipped that part, but that's so usually we'll focus on in the initial meeting. I certainly want to make sure that there have been material changes in circumstances. I think there's a lot of people out there that would like to modify custody, but not everybody can. So it's important that we sit down and we go over what those factors are. But yes, to get your foot in the door, essentially, we need to show those material changes in circumstances. And then once you're able to get your foot in the door, so to speak, then the court applies the best interest of the child standard in our cases as well.
Will they bifurcate those cases, meaning having two different contested hearings, one on change of circumstances and one on the best interest factors?
That's interesting. And no, I've never heard of that. We don't do that in Georgia. Is that something that they do in Ohio?
Yeah, if I request it, it's not always, but I can bifurcate a hearing to have a change of circumstances hearing. And then if that is successful, then we can move forward on a best interest factors hearing for the second half of the two-tiered system on changing custody. Now, do you guys also have a difference in, like for here in Ohio, if we want to change custody, the change of circumstances applies to custody and custody to shared parenting. But when somebody wants to terminate shared parenting, it's just best interest standard.
And by shared parenting, do you mean where they have equal parenting time?
Equal parenting time, equal decision making. I apologize. I know it varies from state to state.
No, that's okay. No, we don't. What you described isn't something that we have here in Georgia. No. It would be a modification of custody. I suppose under maybe with what you've described, if we have an equal parenting time arrangement, you'd have to file for a modification of custody if you no longer want that. Okay, that's a good point. I see your point there. You're saying you have to file for the modification of custody versus just the visitation if it's equal.
Correct. Yeah, okay. So like here, and I probably said it poorly. So shared parenting is an order in Ohio, and that is the sharing of the decision making between parenting time or between the parents and parenting time 50-50, whatever the parenting time is. That's different. That's parenting time. That is a modification of parenting time. That's best interest. But if a parent wanted to go from a shared parenting order to one of them just having legal custody, being the sole legal custodian, then that is the best interest standard and not the custody to custody or custody to shared parenting, which would be the change of circumstances and best interest standard in Ohio.
It sounds similar here. It sounds like you have a few more steps there, which I like actually, but not here. I will say with the visitation, if you want that modified, from my experience, it could be pretty straightforward and you don't need to show much in the petition. In Georgia, at least, you have to show that there hasn't been a modification of visitation in 2 years since the last order, and you can file for one. I'd say the easiest example to give would be, from my experience, a situation where the parties deviated from their parenting plan or their court order. They followed a schedule for whether it's several months or maybe some years, and then they get into an argument. One parent says, you know what, I'm not following that schedule anymore. And they want to go back to the old one, which they can, because that's the only court order. But it's usually pretty good grounds to get the requested modification if you can demonstrate that they have followed the schedule for several months, deviated from it, and it was working out well. Oftentimes that's just a decent example, I think, where you can ask for a modified parenting schedule. Other than that, it may be a situation where I think another good example would be if a parent had limited visitation, whether it be supervised or limited for various reasons, could be substance abuse, could just be mental health issues in general. If they want to get more parenting time, they'd be filing for a modification of visitation, not custody typically. And those are, good grounds as well. And I don't want to say it's an easy case, but if someone can show that they are no longer abusing substances or they've got their mental health under control, there's a good chance they're going to be successful in getting more parenting time or maybe getting the supervised visitation taken away.
If you had that client, that maybe originally during the original divorce was ordered supervised parenting time due to substance abuse or mental health issues, after that case is over, what is your advice to the client on what to do in the meantime before they file to modify in the future? What steps should they take to help them succeed in a modification down the road?
That's a good question. Well, it depends on what facts, I guess, they have. So we're talking about maybe substance abuse, you said, right?
Yeah.
Well, if they go to rehab, and they're successful in that, I wouldn't say to typically just file for a modification as soon as you get out of rehab. But you want to show some long-term success. And I know a client may come in and say, I just finished rehab. I want to file for a modification. My recommendation would be to wait a little longer to show that you've done rehab and you've taken and continued to follow the steps that they tell you to take, whatever those steps are, whether it's continuing to go to therapy weekly, going to AA meetings or Narcotics Anonymous meetings, whatever it may be. You do that for a period of time. You get yourself in order, essentially. You're working. Maybe you can have some witnesses testify to how well you've been doing. So I would wait several months probably to file for a modification. But if they can demonstrate that they've been clean and sober, they're working, and maybe they would take drug tests, just weekly or every other week. And I know sometimes they'll be put into a program that submits random drug screenings. That's probably what I would recommend. And that way you could show that they've been subject to random drug screens on their own volition. I think that's going to look better than having a judge order you to do it. So basically, I would be strategizing with the client to come up with the best plan of action to show the judge that this person is a new person. They are no longer who they were when the order was entered, and they deserve to have, their children deserve to have the parenting time with that parent that they haven't had for however long they've been under that order. So that's a good question. I guess it changes from case to case. Is there anything else you would recommend doing?
I mean, everything that you say, I agree with 100%. I was actually sitting there thinking, because there's so many different kinds of drug tests out there, is it better for a client to do, regular urine screens, random urine screens, do hair follicle tests, to submit to the nail tests? Does one seem to be more persuasive to a court than the other, or is it just the frequency of them on, how many do you have that show a clean test? And then obviously making sure that your client is aware as soon as you file, you're probably going to have to be subjected to an additional test by the court, by, whoever the court utilizes to facilitate their drug tests. Some courts have places within the building to submit to a drug test. Some will send you to a lab and say you have to get it done within the next hour. Making sure the client is aware of those things, when they file, that those are all probably going to be consequences or things that are going to occur when the case is pending. But 100% agree with everything you said. If it's a matter of a mental health issue or mental health concern, making sure that they stay in therapy, making sure that they, are regularly seeing their counselor, psychologist, psychiatrist, taking their medication as needed, and really showing improvements in those areas as well, because that's something that often will happen in our line of work in custody cases, with visitation and or custody modifications.
Okay. No, that makes sense to me. I think that's a good approach. Other factors that could warrant a modification in custody I didn't touch on. There was one that I did want to discuss, and I'm interested to see if it is a factor in Ohio, because I've wondered what it is like in other states. So in Georgia, when a child turns age 14, they have a right to make a parental selection, is what it's called.
Wow.
So parents are getting divorced. The law, I think before 2008, the way it was structured was basically that 14-year-old gets to decide. They did change the law in 2008 so that the child can decide, but it's still subject to the best interest standard. So the judge can say, I don't think it's in your best interest to be with that parent. But it is a big factor in Georgia. Sometimes we like it, sometimes we don't. But I'm curious, is that anything that's done in Ohio as a factor?
Yes and no. It's not statutory.
Okay.
A lot of our counties differ from county to county, and they have various local rules that are applied differently. Some counties might have, when they look at their standard order of visitation, a section that says, and it's not 14, it's 15 or 16 is what I've seen here in Ohio. But, maybe their standard order for that 15 or 16-year-old will be, as arranged between the child and the parent.
Okay.
But statutorily, I think that the older that the child is, the more weight their opinion is given. And you can always file an in camera so the child can, express his wishes directly to the judge or via guardian ad litem or friend of the court or whatever your jurisdiction calls that attorney that's issuing a report in the best interest of the child, but not statutorily. Like I said, it does seem to vary from county to county, but the older that the child is, the more weight what they want the court gives.
Yeah, in Georgia, the statute actually says that if a child age 14 makes the parental selection, that in and of itself constitutes the material change in circumstances. So I thought that's, I guess, rather unique to Georgia. So if a 14-year-old with divorced parents decides they want to live with the other parent, that's all you actually need to file for a modification of custody. That kind of gets your foot in the door, so to speak. So it's an interesting difference, I suppose, with the states. But I haven't heard of too many other states that have the same statute as Georgia, which I find interesting. But some people like it, some don't.
Yeah, that's very interesting too, because I know we have case law that says the child's wishes to live with the other parent isn't enough. There has to be more than just the child's. It's not that it's not a factor to be considered, but that alone does not necessarily warrant a modification of a parenting time schedule and or a custody order. It has to be, I guess, the totality of the circumstances and not just that alone.
Yeah,
it's fascinating how different it is from state to state.
Yeah.
Across the river and, in Kentucky, they do default shared parenting and default 50-50 parenting time. So everything's reversed, and you have to, if you want to file, and I don't practice there that much, but if you want to file for a modification or a deviation, or you want sole custody, there has to be I can't remember the exact words they use, but something incredibly detrimental to the child.
Wow.
Like you're going to have shared parenting, joint custody, or 50-50 time unless that parent is addicted to drugs or unless that parent is physically abusive. And I apologize out there to those Kentucky practitioners because, again, I don't practice there that often. So I'm just kind of pulling it from memory, but it's vastly different from state to state how the different laws regarding custody and modification of parenting time are applied. And it's kind of why we're so fascinating, because we can have these conversations with each other and talk about the differences because it always amazes me how different other states practice the same thing that I do, Yeah,
that's very unique. That's vastly different than most states, but that's interesting to hear. I didn't know that about Kentucky.
Yeah. I think there's a couple of other states that have started doing the same thing. And I know we had a bill, I don't know where it is in the House, looking at adopting something similar to that, but that would completely change the whole dynamic of Ohio custody law.
Yeah. Wow. So there's one other point I think I was going to discuss that I do have clients come in and ask me about for changing custody if their parent has the other parent is violating the parenting plan.
Sure.
So my experience is that one violation in and of itself is rarely going to constitute grounds for modification. But what I usually discuss with my clients is that if you want to use that as grounds for modification, you really need to, step one is get a contempt order. And in my experience, it's going to take probably multiple contempt orders of violations of that parent violating the parenting plan for that to be the grounds for modification. But that is something I'll often have parents come in and discuss with me. And I think the most clear-cut example that is egregious for contempt would be if someone's denying parenting time or withholding visitation. If that happens repeatedly, that could be grounds for a modification. And in my experience, that's going to be more so with younger children. If they're withholding the younger children, I think that would be good grounds for a potential modification, but not always. But I do have that come up a lot with some of my clients as well that come in.
And when you're saying modification, you're talking or referencing modification of custody, correct?
Yeah, yes, a modification of custody, not the visitation or parenting time. Yeah.
Yeah. I just wanted, I'm picking up what you're putting down, but I know we talk legalese and, so.
True, good point.
Clarification purposes. What about those harder issues? When you get that client that comes in here, and I know that this is the bad word and that psychologists don't use it anymore, but they say, opposing party or my ex-spouse is alienating the children against me.
Yeah.
What
So
advice do we give those clients? Is that a custody case? Is that a modification of parenting time case? Is that a combo?
maybe a combo, and it depends, I guess, on what is being done. By alienating, it could be, I guess, withholding parenting time, but that's sort of just a physical contempt issue. But alienating for me would mean saying, things about that parent, and I guess speaking about them negatively or discouraging the children from doing things with that parent. That's sort of what I generally think of alienation to be. It's hard to prove in my experience. What I would recommend to clients, depending on the children's ages, is we try to find a way to get them into therapy, or with a psychologist would be better, I suppose. And they, in my experience, need to be the ones to dig that information out. I've had some successful cases with custody, like psychological custody evaluations, where the psychologist made that determination, even if it wasn't always used. The word alienation wasn't used. I mean, words like the parent's a restrictive gatekeeper for, in an effort to exclude the other parent. Those are some terms I've heard. And that's typically, for me, how we're going to be able to prove that to the court. It's hard to go into court and say, so-and-so is alienating my client, because it is a term, it's not necessarily a legally recognized term in Georgia, but it makes sense. I mean, it's a common sense term, I think, generally, that most people get. But we don't recognize that legally here necessarily in Georgia. Is that something recognized in Ohio?
It's not. It is what you indicated. Everybody knows what it is. We don't know what to call it, right?
Yeah.
It hasn't been adopted by the DSM-5, so there's different usage of the word or different ways to phrase it. Target parents, alienated parents, isolating behavior. Whatever the circumstances are. But those cases, like you said, they're very, very hard to prove, and there's always that kind of pushback as to when we get to the best interest part regarding the kid, right? So if the child has been so, again, lack of a better term, alienated to the point where they will refuse to have any parenting time with the other parent, and they are kicking and screaming, and they, don't want anything to do with them, is it more psychological detrimental is to the child to force that than not? So there's so many different interesting factors that go back and forth on that we could probably have a whole other podcast about, versus I completely threw up from our modification of parenting time and custody. I apologize for that, but just thinking off the top of my head. But yeah, those cases are always a little bit more difficult and interesting, and there's never one right answer for them.
Yeah, that's a good point. I deal with a lot of cases where I'm on both sides of the coin, where the children or child is refusing to go, but that would probably be a whole nother podcast. Those are tough cases, and that varies from judge to judge, and enforcement of it, and depending on the children's ages, that comes into play. But I won't dive, into a deep dive into that subject, because you're right. It probably would be a whole nother podcast. Maybe we'll
right.
That. Yeah.
Well, then I guess to recap, and you tell me if I said anything wrong, when we're talking about modification of visitation versus modification of custody, what we really need to focus on is that when we're doing custody, we're looking at a change of circumstances and best interest. And then when we're doing modification, we're looking at the best interest of the child. Is that accurate?
That's perfect. Actually, that's exactly right. Yep.
Hey, I've been around the block once or twice. All right. Well, thank you so much for your time today, Kevin. I really appreciate it. And thank all of you guys for tuning in to Cordell's Men's Divorce Podcast. I hope everybody has a great day.
Thank you, Marcie.